Across America, BP supports more than 275,000 jobs to keep energy flowing. Jobs like updating turbines at one of our Indiana wind farms and producing more oil and gas with fewer operational emissions in the Gulf of Mexico. It's and, not or. See what doing both means for energy nationwide at bp.com/investing in America.
The stress and crowds of holiday shopping can put a damper on your holiday spirit, and you don't always find all the perfect gifts you're looking for. The Virginia Lottery's games make easy and tremendously fun gifts for all the adults in your life, even you. Spruce up your gift-giving game this holiday season with the Virginia Lottery. The Virginia Lottery's holiday scratchers are a gift any adult will love. Treat yourself to some winter wonderment and play the lottery's holiday online instant games from anywhere in Virginia. Visit valottery.com/holiday. Please gift responsibly. Lottery games are not for minors.
Hey, it's Ryan Holiday, host of the Daily Stoic podcast. When I bought my first house in 2013, part of the way I paid for it was we would rent it out on Airbnb in Austin when there was South by Southwest or F1 or ACL. And then later, when that tiny little house became my office, I would work there, I'd do my writing during the week. Then on the weekends, we'd rent it out to people who were coming in from out of town on Airbnb. And you may be sitting on an Airbnb and not even know it. You've probably had the same experience. You stayed in an Airbnb and thought, this is doable. Maybe I could rent my place on Airbnb. And it's really that simple. You can start with a spare room or you can rent your whole place. Maybe you're traveling to see friends and family for the holidays. While you're away, your home could be an Airbnb. Your home might be worth more than you think. Find out at airbnb.com/host.
Content warning, this episode contains discussion of the murder of two girls.
Well, it feels like the last several Mondays in a row, there have been new filings in the Richard Allen case, or the Delphi murders case, if you will. And this Monday is no exception.
Yeah.
The defense this morning filed a supplemental motion for their Franks hearing.
And we're going to talk about what that is, what it includes, and what it all means. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet, and this is
The Delphi Murders. Supplemental motion for Frank's hearing.
So why don't we start by reading a little bit of this?
On the 18th day of September 2023, defendant Allen filed his motion for Frank's hearing. In paragraph 8 of said motion, defendant Allen made general references to the preliminary showing required prior to the admission of the Franks evidence at a suppression hearing. However, defendant Allen now realizes that he did not articulate in detail the actual burden of proof associated with said preliminary showing.
So that's basically why you have a supplemental filing, because you want to include something you didn't include in the previous filing. And they're saying, well, we didn't explain what we think the burden of proof is to actually have a Franks motion.
So this is getting into the legal questions at the heart of a Franks motion. Is that right?
Yes. For instance, when, as we all know, when someone goes on trial for a crime, the burden of proof is beyond a reasonable doubt.
Yes.
Obviously, if you're just requesting a hearing, you don't want the burden to be that high. Also, you don't want to just have it to be an automatic hearing. Like if I go and file a motion with the court, I want there to be a hearing to determine whether or not I should be king of England. I'm not going to get that because obviously that's absurd. So there has to be some standard there has to be something within the motion that makes the judge think, well, there must be something here that we have to talk about. But what should that standard be?
Right. That's very interesting. And we've had some listeners reach out and say, is a Franks hearing automatic? Will they get that because they asked for it? If the judge doesn't give that, does that mean she thinks they're full of it? And we just don't know. So this is where the defense is saying, here's what we feel the standard is, and here's why we feel these circumstances have met that standard.
And obviously, the way these things work, you would expect the defense to explain, here's what we think the standard should be in such a way that they would fall comfortably within that standard. And you might expect the prosecution to come up with an argument that says, well, we don't think they meet this standard, and here's what we think the standard should be.
And that's typical, where you have kind of both sides just arguing against each other, I don't, if the hearing is granted, that means that they met a certain level of standard according to the judge. Doesn't mean the judge is saying that this is all accurate. It's just saying, yeah, they're right. Legally, we need to have this.
And they cite some cases, and we'll discuss that. This brief is much more focused on that narrow legal issue of what the standard should be for a hearing than the previous memorandum filed by the defense.
We talked about the Franks memorandum, and I think from our listeners, some people really liked it in the sense that it was very accessible, easy to read, and included a lot of intriguing information about the defense's alternate theory. That being said, 100 pages of it essentially had nothing to do with Frank's issues. It was just more of a press release, essentially letting the media know, here's who we think did it. And I mean, that's understandable given that, gag order is in place. So filings are essentially the only opportunity for the defense to put out their narrative to counter the narrative that Richard Allen is guilty. But there was a lot of information in the end about the Franks issues at the heart of this case, which center around what, from my reading, is the defense's contention that now Sheriff Tony Liggett massaged, at the very least, witness statements to get probable cause against Richard Allen. So what they're arguing is that, therefore, the search should be thrown out. If you lose the search, you lose the gun, and you lose the confessions, in my mind, because he's only in prison because of the gun. So this is a very important situation going on in the case right now. The whole case could hinge upon this.
Yes.
And I just want to say, this document is much more in line with what you'd expect from a legal filing in terms of tone and how it's laid out. It does not include the same snappy, media-friendly language that the Franks memorandum did. A lot of people hated that Franks memorandum. They felt it was gratuitous in its description of the crime scene. They felt that the language was unprofessional. So there's a lot of controversy around that Franks memorandum, but this document is just night and day, totally different. So I just want to point that out.
So let's get into it some more and try to figure out what their argument is. What do you need to have a Franks hearing?
To mandate an evidentiary hearing, the challenger's attack must be more than conclusory and must be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or of reckless disregard for the truth, and those allegations must be accompanied by an offer of proof. They should point out specifically the portion of the warrant affidavit that is claimed to be false, and they should be accompanied by a statement of supporting reasons. Affidavits or otherwise reliable statements of witnesses should be furnished, or their absence satisfactorily explained.
That's actually, they're quoting directly from the United States Supreme Court decision in Franks versus Delaware.
So that's where it all came from.
Right.
That's the original case that they're dealing with.
So this is, they're explaining this is what they're looking for in the actual hearing. It shouldn't be automatic. It shouldn't be, I want to get Tony Liggett up on the stand so I can make him look like a fool before the trial. I want to have a Franks hearing. It has to be something more than that.
You have to have a basis in something. And if the judge, and again, if the judge finds for that, that's not the end all be all. It's ultimately what will come out of the Franks hearing and what she will decide based on that.
So they don't want it to be a fishing expedition, but the question is, again, how much of a basis do you need to get this hearing? And the defense addresses that in this motion.
The question becomes, what exactly is the burden of proof associated with the preliminary showing? In People versus Lucente, the Illinois Supreme Court addressed the issue of the burden of proof related to the preliminary showing. In pertinent part, the court stated as follows. Franks expressly states that in order to prevail at the hearing, the defendant must prove his claim of perjury by a preponderance of the evidence. If the preponderance standard is to apply at the hearing, it follows logically that the threshold requirement must be something less. Thus, the precise standard lies somewhere between mere denial, on the one hand, and proof by preponderance on the other. Put another way, the preliminary burden must be sufficiently rigorous to preclude automatic hearings in every case, but not so onerous as to be unachievable. Therefore, Allen's burden could be akin to the well-recognized burden of reasonable suspicion, the lowest of the standards employed in the criminal justice system.
Well, one thing, before we discuss this particular part, one thing that jumps out at me, and I think you're smiling, I might see it jumping out at you. Why don't you go ahead and say it?
Illinois? Uh-oh.
So this is an Illinois case. Why does that make you laugh?
Well, when we had our last in-person hearing, Brad Rosie got dinged in the courtroom by Judge Frank Gull for citing a lot of out-of-state case law. And to me, a layperson, I didn't see anything weird with that because, you know, like, well, we live in the United States. Wouldn't it all be relevant? But apparently it's somewhat important for Indiana-specific case law to potentially make its way into some of these filings. So I'm wondering if we're going to see some more Indiana case law as we go through this and potentially see some of him kind of responding to her criticism in that situation. But different states,
yeah, it's interesting to look at how other states do things, and that can be influential. It's not controlling the way that if it's a Supreme Court decision or an Indiana case, it's not controlling. I'm going to really oversimplify things to a ridiculous degree, but it's almost like saying, I want to go to Disneyland, Mom, and you should let me go to Disneyland, Mom, because the girl down the street, her mother let her go.
Okay. Yeah, I like that. It's a very simplistic, but very, yeah.
That's overly simplifying it, stripping it away from nuances, probably in an offensive way, but that's a little bit what the gist of it is.
Okay, so a critic might look at this, someone who's a proponent of what the defense is saying might say, listen, Illinois is an innovative state in terms of its legal precedents, so maybe we should follow what they're saying. And a critic might say, that doesn't matter. What matters is what goes on in the Hoosier state.
But yeah, so it's interesting. I'm curious why he didn't cite Indiana cases.
Especially since he was, again, dinged publicly, verbally by the judge in the last hearing for that. So
with all of that said, why don't we actually discuss a little bit the substance? What do you need for a preliminary hearing? The defense is arguing that it should be reasonable suspicion as opposed to proof beyond a reasonable doubt or preponderance of proof. Reasonable suspicion is the lowest standard. Reasonable suspicion is something if a police officer sees me walking out of an apartment that he knows is owned and operated by a drug dealer, he might have a reasonable suspicion that I've just bought some drugs and he can frisk me.
Okay.
But obviously, if you just see me walking out of this apartment, that's not enough to say, okay, Kevin, now we're going to take you home and search your home. We're going to search your car. We're going to arrest you. Because it doesn't rise to the level of probable cause. Does that make sense?
That makes sense. It gets you a few things like a frisking, but it doesn't get you everything.
In other words, law enforcement or whoever has seen something, they've observed something, which makes them think something might be going on, and they have a little bit of a right to investigate further. It's not probable cause. It's not a preponderance of proof. It's not proof beyond a reasonable doubt, but it's a little something. And so basically, the defense is saying, we've done that. We've seen a little something that we feel should be looked at further.
I'm going to ask a question, and I have no idea the answer. What on earth is a preponderance of proof? I've heard that word before in a legal setting, but I don't know what it means at all.
Preponderance of proof basically means more than 50% of the proof leans in one direction.
Okay. So does that mean the suspicion one that we just talked about is like less than 50%?
Yes.
Oh, wow. Okay, dang.
If you see me walking out of a building where
You could be a social worker who's helping the drug dealer like get their life back in order. You're not necessarily buying drugs there. You could be visiting a family member who lives there.
Yes, I could be a TV repairman or a plumber.
Yeah.
There's a number of reasons. Whatever evidence you have in your mind that I've committed a crime because you see me walking out of this apartment, it's less than 50%.
Way less. Yeah, it's you're basically you could very well be at the wrong place at the wrong time.
Yes.
And yeah, it's kind of, so this is the lowest, but it's what they're arguing makes sense for this situation because they're saying that the burden shouldn't be so onerous that you can't get to it, essentially.
Yes.
So might as well have it on the lowest setting of difficulty, so to speak, because otherwise people might not get Frank's hearings because it'll be too hard to.
And you don't want it to be too easy because then anybody is going to ask for one just to delay things.
Delay things and smack law enforcement around in anticipation of the trial.
At the Murder Sheet, we spend so much time digging into crime stories that sometimes it's difficult to find the time to plan out and cook elaborate, nutritious meals. That's why we are so excited about our sponsor, Factor, America's #1 ready-to-eat meal delivery service. Our sponsors make this podcast possible. So if you go to factormeals.com/msheet and use our special code MSHEET, you're not just getting half off this high-quality meal plan. You're supporting us too.
So I'm obsessed with Factor. I had their creamed corn chicken and their tomato basil chicken risotto recently. Both were delicious. That risotto in particular was amazing. Plus, the whole process was a breeze. All I had to do was pop the meal into the microwave. The food was tasty and flavorful, which is no surprise given that each recipe is specifically crafted by chefs and approved by dietitians.
Having Factor during the hectic holiday season has been a boon, especially with us pumping out so many episodes. Head to factormeals.com/msheet and use code MSHEET to get 50% off. That's code MSHEET at factormeals.com/msheet to get 50% off.
Have you heard? You can listen to your gripping investigations ad-free. Good news. With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app or visit amazon.com/truecrime ad-free. That's amazon.com/truecrime ad-free and catch up on the latest episodes without the ads.
Hey listeners, this is Candace DeLong, the host of Killer Psyche. Imagine all your audio entertainment available in just one place. That's what the Audible app is all about. With Audible, you can always find the best of what you love or discover something new. Audible has an incredible selection of mystery and thriller titles and originals like Something Ain't Right by Roger and Zachary Stringer, The Space Within by Greg O'Connor and Josh Fagan, and Moriarty, an Audible original. Membership includes access to Audible originals, podcasts, and tons of audiobooks that you can download or stream as much as you want. And as an Audible member, you can choose one title per month from an ever-growing catalog of titles to keep. The Audible app makes it easy to listen anytime, anywhere, whether you're traveling, working out, doing chores, wherever your day takes you. New members can try Audible now for free for 30 days. Visit audible.com/DeLong or text DeLong to 500-500.
Let's get back to it.
The purpose of the substantial preliminary showing requirement is to discourage abuse of the hearing process and to enable spurious claims to wash out at an early stage. At its very foundation, the preliminary showing requirement is intended to discourage litigants from utilizing the suppression process as a means of seeking an additional opportunity to cross-examine the state's witnesses. Hence, the rule requires that defendant assert more than basic allegations. Instead, defendant must offer up affidavits and other supporting documents to prove up defendant's claims that state actors engaged in conduct that demonstrated intentional or reckless disregard for the truth. Once again, explaining why there should be standards in this situation.
Yes, which I think we can all agree to. So the defense is saying there should be standards, and they're going to elaborate why they think they've met those standards.
And in that paragraph, they cited Franks v. Delaware again. So a Supreme Court case that absolutely has relevance for Indiana law. In People v. Lucente, the defendant was charged with possession of a controlled substance with the intent to deliver. The defendant's arrest was driven by a Chicago police officer's execution and submission of a complaint for a search warrant. The complaint was based on evidence provided by a reliable and unnamed informant that the officer claimed to have worked with on numerous occasions prior to filing the complaint. The informant claimed to have visited defendant's apartment and purchased marijuana while inside. The complaint also in detail articulated the reasons why the officer found the unnamed informant to be reliable. Based upon the officer's sworn statements, a warrant was issued and drugs were recovered in the defendant's residence. This recovery led to the defendant's arrest and filing of formal charges. The defendant responded by claiming that he had an alibi. Attached to his Franks filing, the defendant included several affidavits signed by defendant's family members indicating that he, defendant, was at another location at the time the unnamed informant claimed to have rendezvoused with him at his home. Despite the fact that all affidavits offered by the defendant were statements from family members and therefore somewhat self-serving, the court still found that the defendant met the threshold requirements to offer up the Franks evidence at the suppression hearing. This is to say that the very nature of an affidavit and its inherent indicia of accountability and accuracy was enough to overcome the relatively low standard of proof required to make the preliminary showing required by Franks. In this case, defendant Allen has done far more than offer up self-serving affidavits. In fact, the bulk of supporting documentation in defendant Allen's offering includes, but is not limited to, affidavits from law enforcement officers working the case, sworn deposition statements from law enforcement officers, numerous police reports, and audio and video of witness statements taken by law enforcement officers during the investigation. The veracity of the supporting material offered up by defendant Allen is far more reliable on its foundation than self-serving affidavits offered up by the defendant in People v. Lucente. Therefore, it stands to reason that defendant Allen would likewise meet the requisite burden of proof for the preliminary showing such that his Franks evidence should be admissible at the suppression hearing.
So they're explaining there, here's a case where it was granted based on what they describe, I think accurately, as self-serving affidavits from family members. And they're saying, hey, we have a lot more than that. We have statements from law enforcement officers and such that we feel make this rise to the level of, at the very least, there should be a hearing so these issues can be aired in full. I don't think at this point we have enough information to make a fair conclusion about whether or not the ruling should come down the way they want in the hearing. But I do think that they are correct that these allegations are serious enough and are supported by at least some evidence from law enforcement that a hearing is absolutely justified.
I agree. And despite the fact that this is all based on an Illinois case, it seems reasonable in the sense that there's, they need to look at this essentially. And, one thing I don't like is people jumping into conclusions so early. We get so many emails and just, talking with people, you feel like some people have absolutely made up their mind. Tony Liggett is a liar, throw him in jail. And then other people are saying, oh, the defense is just making it up. And let's just see what happens. Let's see what happens at the hearing. What's wrong with waiting before we jump into one camp or another? That's my question. I think keeping an open mind and not condemning someone, whether that's a law enforcement officer being accused of something or a defendant being accused of something, I think that's the best way to go in a complicated case like this, where there's always some twists and turns we're not expecting.
if you think the defense is full of it and making up fake allegations, then you should absolutely want a hearing.
Yes.
Because that would be exposed to the hearing. And if you think there's absolute merit to the defense allegations,
You should also want a hearing so they can have it out.
again, without expressing any opinion on how Judge Gull should rule in this hearing, I think we can all agree that we'd like to see a hearing.
Judge Gull should rule with the facts. That's what she, I mean, and I believe that's what she will do. That's what she has a reputation for doing. And I think that she has the prosecutorial background. At the same time, she's thrown out cases based on fundamental issues of fairness and violations of defendants' rights. So I think that she's a judge who is equipped to tackle some of these issues and really get to the heart of what's going on. That's just my assessment. We did those profile episodes about her, and we cited a few cases that she actually threw out.
So yeah, I would think that if she agrees with the allegations in the defense motion, I wouldn't be surprised if she threw it out.
And if she doesn't, then she won't.
And the way to find out is to get more information in a hearing.
Now, interestingly enough, in the next few paragraphs, we'll paraphrase, there is another case discussed, also from Illinois.
These cases are on point, but I haven't sat down and done research on Indiana cases. But I would assume there's some on-point Indiana cases as well.
It just seems a little bit risky given that this specific issue is called out in the past. So I'm even though it seems like relevant to me, the fact that the judge brought it up last hearing, I'm a little surprised that there wasn't some let's mix in some Indiana cases for good measure.
It can be interesting to see how other judges, even in other states, have handled complicated issues.
No doubt.
Because in life, if you're going through a complicated situation, maybe, there's this person in California that I found online. They've gone through it too. Here's how they handle it. Maybe that can offer me some guidance.
Right. But ultimately, it just seems like since it was raised last time, you would be worried about doing it again, and you would at least try to put some Indiana cases in here just to have something to point to. So it surprises me. And it makes me wonder, is the Indiana case law less friendly to what they're trying to argue for? We don't know that. I don't know.
I haven't sat down.
I feel like
researched.
if there was some really good Indiana case law, we'd be seeing it in here. So I guess I'm flagging that.
But that's just speculation.
That is complete speculation on my part.
Let's get back to the conclusion of this and see how they wrap it up.
Assuming that the necessary threshold showing has been made so that a hearing must be held, the next question revolves around who has the burden of proof and what exactly is the legal standard at the suppression hearing. Franks holds that the allegation of perjury or reckless disregard must be established by the defendant by a preponderance of the evidence. This standard and the circumstances surrounding evidentiary showing are referenced in paragraphs 6 through 10 of Defendant Allen's motion for Franks hearing previously filed with the court.
So what they're saying there is, assuming Judge Gull gives us a hearing, what do we have to do in order to win that hearing? And they're saying, well, according to our reading of case law, all we need to do is offer a preponderance of the evidence, which, as we've discussed, means 51%.
Okay, that makes sense. So they're not just they're arguing that the baseline for getting a Franks hearing is reasonable suspicion,
And
which is just more the vaguest of kind of the easiest hurdle to go over.
Which is basically, it's more than just a hunch. They can't just say, Baldwin and Rosie didn't just wake up in the middle of the night and say, oh, I've got a feeling something is bad here. You have to have seen or observed something, like me walking out of a drug dealer's home. And
preponderance is a higher hurdle.
51%.
And that's what they'll need to get to, according to them,
according to their reading of case law.
To win the Franks hearing. Now, I imagine that Nick McClellan, the prosecutor in this case, will probably come back with something saying you need beyond a reasonable doubt for both or something. He's going to have an incentive to try to hike up the requirements, I would imagine, for both the hearing and winning the hearing, but at the very least winning the hearing.
Yes.
He may want a hearing in the sense that, just get it over with and share their side of the story, right?
Yeah. If someone said awful things about people working for me that I believed were untrue, I'd want to defend those people.
Yes, and so that's his opportunity to do so. But I imagine he'll argue that there should be a very substantial hurdle to win the Franks hearing.
Yes. And maybe even to have the hearing in the first place.
Yeah. So, I mean, given that he's accused the defense of grandstanding, having a hearing in the first place may play into what he feels is grandstanding from the defense, and he may not want it in that sense. So, I mean, we're just trying to anticipate how the response may be, but obviously we're speculating here.
And in fairness, there's nothing grandstanding about this.
This is a totally normal filing. Yeah, this is not grandstanding. I mean, I think the defense and the prosecution are obviously coming at it from very different sides. I think the prosecution likely seems to think that the allegations in the first place are grandstanding, but this is a very muted case law based filing that reads more like what you would typically see in a case than the Franks memorandum.
Exactly.
I mean, should we, do you have any sense of what may happen next?
It's always possible Nick McClelland will file a motion saying, here's what I think. Here's what the prosecution thinks you need to establish in order to have a hearing. Here's what we think you need to do to win the hearing. And as you say, he would probably say you need more evidence to have a hearing, and you certainly need more evidence to win the hearing. And all of this is stuff that Judge Gull would have to take into consideration.
If Judge Gull grants the hearing, does that mean that she's saying Tony Liggett is a liar?
No. It means that she's saying there is out there reasonable suspicion.
And we need to get to the bottom of this.
Yes.
Okay. I just want to... Sometimes people read into moves in this case in an overly broad way. And I think it's important to kind of say, this is all a process and all parties are going to be having arguments and back and forth about how to handle different aspects of this. And the Franks hearing is a very good example of that. So anything else to add before we go?
I don't think so.
All right. Well, thank you all so much for listening. Hopefully this cleared up some questions you all had.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.